The idea of these webinars is to help our accountant partners. Sometimes it's a refresher on a change in the law or some information about a particular topic that we find is relevant for accountants and their clients. Welcome back to any of the returning attendees from our previous two webinars, and to any of the first timers, thanks for joining us. We do try to make these webinars as informative as possible, and we invite any questions throughout the webinar through the dashboard on the right hand side there, entering into questions. We also have a link on the chat box to a Dropbox folder which contains the slides that you can see. There's also a handout that Jeremy will go through later in the webinar with some very important information that one of our strategic partners has allowed us to use in this webinar. So today's webinar, as you can see, is about employees versus contractors. Now, I'll go through the different types of employees, explain a few things about independent contractors and the difference between a contractor and an employee. Jeremy will then kick in, talk about employment standards, policies, and management of employees. So, as we know, in any business, taking on an employee or an independent contractor is an important step in that business, and we say you need to put some things in place to make sure it's done properly. All right, so into employees. So the different types of employees. We have a permanent employee. So that can be full-time, or it also can be part-time. So a full-time employee, which accounts for about 75% of all employees, is usually 38 hours per week, and a full-time, or a permanent, part-time is someone that works on set days for a period less than 38 hours per week. As a permanent employee, they are to receive benefits which include payment for overtime, annual leave, long service leave, paid personal leave, payment for things like jury duty, and obviously payment for public holidays. The next type of employee is a casual. So casual employees work on an hourly basis normally, and it's on an as needs basis. Normally it's an irregular pattern of work or hours that they work each week. They're not entitled to, as we know, the benefits of overtime and leave, etc. But in order to compensate that, under most awards, a casual employee is paid 25% over and above the full-time equivalent hourly rate. Casual employees are still protected by unfair dismissal laws, but it's to a lesser extent. So you still need to be careful when you're dealing with casual employees. The other type of employee, which is becoming very popular at the moment, is labour hire workers. That's where staff are supplied through a recruitment agency. They work for short periods of time or for particular jobs. The obvious benefit of using labour hire companies is that the person that's working is not an employee. They're also not an independent contractor, and you don't need to worry about calculating entitlements or whether or not you're going to get into trouble from the ATO for classing someone as an independent contractor when they should be in fact an employee. So labour hire work companies, obviously it's more popular in the building construction industry, and is becoming something that's quite prevalent in a lot of industries. The last type of employee is a volunteer. Typically they don't get paid for their work, and from that obviously there's no tax, there's no super, there's no entitlements that need to be provided to volunteers. However, a volunteer is obviously still has rights, and that is to a safe working environment. So just because you've got volunteers doesn't mean you don't need to comply with having occupational health and safety requirements. So there are different types of employees. Now, the difference then is between an employee, which are those things which most people know about, and what's called an independent contractor. Now, a lot of people try to have their staff as independent contractors, and it was popular to avoid the administrative costs of withholding tax, paying superannuation, those sorts of things. But the main differences, and there's a number of indicators that have been developed through case law over the years, there's a number of indicators that means how you tell the difference between an employee and an independent contractor. There's a good tool that's on the ATO website that we'd encourage anyone to use if they're unsure, which goes through a number of questions, and from that the ATO spits out whether or not that particular person should be an employee or should be an independent contractor. The main indicators are control. With an employee, they perform the work under the direction and control of the employer, and that's on an ongoing basis. With an independent contractor, they have a high level of control as to how the work is ultimately to be done, because it's them doing the work. The other indicator is hours of work. So obviously with an employee, they're generally set hours. Obviously casual is not, but an employee expects to be working a certain period of hours each week. Whereas an independent contractor, that's under the agreement that they reach with the head contractor, and they get to decide how many hours work they're going to work on a particular job, because all they're doing is completing a specific task. So if they want to go fishing at 3 o'clock, they can head off and go fishing at 3 o'clock. If they want to start at 4 o'clock, then they can do that. One that seems to have missed on the slides is the expectation of work. So obviously an employee usually has an ongoing expectation that they're going to be employed the next day, whereas an independent contractor, as I said, it's for a specific task. Once they complete that task, there's no expectation that they're going to be contracted to do the next one. The next indicator is risk. So an employee obviously bears no financial risk. That's always the responsibility of the employer. Whereas an independent contractor, they bear the risk of making a profit or a loss on a particular job. They bear the responsibility and liability for any poor work. So if there's something that they've done incorrectly, they may need to go back and fix it. And also if there's an injury that's sustained while performing that particular work, it's their risk. So they ordinarily have their own insurance for those sorts of things. The other big one that most accountants would be asked about by their clients would be superannuation. So obviously employees are entitled to be paid superannuation, whereas an independent contractor is not, and they pay their own superannuation. Tax, which is the other one that accountants would come across quite a lot. As we know, employees, an employer must deduct or withhold the tax for their employees, whereas an independent contractor is required to pay their own tax and their own GST if it's applicable. The other big one that we come across quite a lot is tools and equipment. So as an employee, you expect when you come to work that all the tools and equipment that you need to complete your job is all there. However, in an independent contractor arrangement, they're expected to bring their own tools and equipment. For an employee, if they were to buy their own tools for a particular reason, there should always be an allowance that they're reimbursed or some other way for those tools that they might buy. The method of payment is the second last indicator. Obviously an employee expects every Friday or whatever it might be that they're going to get paid, whereas an independent contractor only gets paid once they issue an invoice, AVN's on that, and then the terms of payment are as per agreed or as per their invoice, whether it be 14, 30 days, whatever it might be. The last indicator is leave. So as I said before, employees are entitled to receive paid leave for annual, personal carers leave, long service leave, etc. Obviously an independent contractor, as the difference, doesn't receive any of those entitlements because they're completing a specific task rather than working for an employer. There are sham contracting provisions that are governed by the Fair Work Act. And that's section 357, 358 and 359. Basically that prohibits an employer threatening to dismiss or dismissing an employee for the purpose of them bringing them back as an independent contractor. It talks about making false statements to persuade someone or influence an employee to alter their current arrangement. So they were brought about to stop an employer basically saying to the employer, look, I'm going to sack you, but come back as an independent contractor and it's going to be easier for everyone. Those provisions prohibit those sorts of things from going on. And the fines for those, if you're in breach of those sections, can be up to $54,000. So quite a significant fine. I just wanted to quickly touch on a recent case that we've seen. It was in the building industry. It was a construction type company, and they at the time were using 10 carpenters. And they classed those carpenters as independent contractors. They were working on specific jobs. There was no sort of expectation that the next week there was going to be another job. They were free to work for other people. The ATO conducted an audit. There was meetings held. Information was provided by the particular owner of the construction company. Unfortunately, it seems that they were a bit naive as to the situation they were in, and information was provided and no advice was sought from an accountant or a lawyer. In the end, the ATO came back after completing the audit to say that those 10 carpenters were actually employees, and this goes back for eight quarters. That obviously following from that there was PAYG that was payable, that super was payable, that penalties and interests were therefore payable, and in the end it was quite a large amount of money that was to be paid by this company for 2 years worth of jobs that they'd always considered independent contractors. They'd paid them accordingly for each job, and it was their belief that it was those carpenters' responsibility to pay tax, super, those sorts of things. So they were faced with quite a financial problem to pay all these debts to the ATO. Fortunately, the ATO does have a process where you can review these types of decisions. And at that stage, the particular construction company sought the advice of a lawyer and a new accountant to go through the submissions that they can make to try to reverse the decision made by the ATO. So as I said, there's a number of cases that have been decided on this issue. And you've got to look at the totality of those indicators, and it's not just one factor that's has any more weight than the others. So you go through all those indicators. In this particular instance, the carpenters, they were instructed on a particular task. They actually issued work orders or period trade contracts for each job. The carpenters determined their own hours to complete the tasks. It wasn't a regular thing, so they could work for other construction companies, etc., etc. So they were free to choose to work for whoever they wanted. The carpenters in this instance bared the risk to make profit. They had their own workers' comp. We didn't pay any super, obviously, as I said. The carpenters provided their own tools. They issued tax invoices. They didn't have uniforms. There were some promotional material that provided to the carpenters, but that was more as a merchandise thing with stubby holders and those sorts of things. So it wasn't a uniform with the company's logo on or anything like that. After those submissions were made, the ATO came back. After considering all the objections, they accepted all of those, and it put the construction company in a position where those 10 carpenters were classed as independent contractors. So the moral of the story for that is, if you are speaking to any clients and they're faced with an ATO audit, that's the time to seek some professional advice about what to include and what submissions can be made, because of the financial things that can come of it can be quite severe. So if you're ever speaking to anyone about those things, that's the time to speak, get some financial advice and some legal advice. All right, that's me done in terms of employees versus contractors. If you've got any questions, type them in and we'll endeavour to answer them. In the interim, I will pass it over to Jeremy to talk about employment standards.
Thanks, Craig. I've noticed there's a few people who have arrived late. I'm not sure whether the chat box automatically updates where we sent through a link to resources. I'm just going to send that through again, just for any of the new people. There were 3 or 4 people who came in late. So that Dropbox has got a copy of the slides that we're talking about today, and also it's got a copy of a handout which I'm going to talk about during my discussion. So if there's no questions for Craig, I'll jump straight in. So I'm going to talk about 3 things today. I'm going to talk about employee standards and policies. I'm going to give some guidance about performance management and also some guidance about exiting employees. Now, the reason that these things are important is because as advisors, lawyers and accountants, we're advising our clients on a regular basis, and often things are mentioned to us about problems with employees. And one of the things that we see in dealing with employers and employees and contractors is that a lot of employers don't take things seriously early enough. So what I'm going to talk about today is really trigger points for you guys as accountants to think about when things should occur, especially when you're talking about issues with clients, so that you can value add to them about what needs to happen in certain circumstances. So as I said, the first thing I want to talk about is employee standards and policies. Why are they important? As a business, it's good to have any standards and policies written down so that there's some continuity of business for your employees. The first big reason is legal obligations. The employee standards and policies set out the rules that govern the business, and also as employers, you need to have some sort of duty of care to your employees, and they teach the staff those things that need to be done in the business and how things are to occur. They're also important to educate the team about how to deal with complaints. If a complaint is raised, you want that to be dealt with in a certain procedure, and so an employee policy will set that kind of information out. Consistency of approach. Again, if a complaint's made and you don't have a policy, often there's an ad hoc approach that people take to the handling of that complaint, and employees love consistency. They love to know what's going to occur. Another one is to enable performance management, and I'm going to talk about that in a bit more detail a bit later. And the other big reason to have employee standards and policies is to scale and to systemize your business. As accountants and lawyers, we all know that to be able to scale a business and to systemize a business is really important, and having those kind of policies in place really does assist you in being able to scale and systemize a business. The second part of employee standards and policies is the structure of a policy, and they're really quite simple, but you'd be surprised how many people don't really understand what that structure should be. There's 4 key elements. The first is an opening statement around the intention of the policy. So if it's about a certain topic, performance management, it will discuss that it's about performance management. The second part would be any definitions that are used in that policy. So if you're using any defined terms that you want to be clear about how they're to be defined, you put that in a definitions section. The third section is a content section, so that's where you have the actual content of the policy and the procedure that people are to follow. And the last is approvals and review. So any employee, when they start, or if you bring in a policy whilst the business is still running, the employees need to agree to it and understand what they're doing. So having an approvals and review process is important to make sure that a business owner can document when employees have actually agreed to policies. And that way too, there can be no argument that someone didn't understand. Whilst ignorance of the law is no excuse, in this kind of thing, ignorance of a policy is quite important. I had a client that I was talking to earlier this week who instituted a policy last week that that employees were not supposed to take vehicles for private use. They did that by an email, just sent out to the employees. They had an issue where one of the employees took the vehicle that night and sent an email saying, "Oh look, I need to take it. I've got an emergency." They then fired that employee the next day for breach of the policy. But of course, they're going to suffer some issues with that because the employee didn't necessarily agree to the policy, and it may be seen to be harsh and unjust to do so. So it's important to actually institute the policy early on and get everyone to agree to it so that you can enforce it. The last part of employee standards and policies that I wanted to talk about were the types of policies. So you'd be surprised to know that there is a broad range of policies that can be in place, and they're not right for every business, but there are policies that are important. Now, what I'm going to go through is not a comprehensive list either. There may be other ones that apply to different businesses, but I'll go through some important ones now. And if you've got, feel free to suggest any others if you think I've missed anything. The first one is a code of conduct. So this is setting out how you expect your staff to behave on site or in your office. Very important. Setting out standards. A lot of people make an assumption that you know the kind of behavioural standards that you want to meet in the office. Well, it's amazing how many employees don't understand that or aren't willing to understand that. So if you have that written down in a policy, then that can work quite well. Leave policy. Setting out the policies for leave and how it's to be taken and what the procedure for taking leave. Again, it sounds so simple, but the amount of times that we have people and clients who have issues with staff who take leave without notice or without reasonable notice, who take leave without making sure that other people are not on leave at the same time so that the business can make sure it can function in the, whilst the staff member is away. Those kind of things need to be thought about in a good leave policy. Very importantly is a sexual harassment, discrimination and bullying policy. So setting out very clear guidelines as to what is a breach of such a policy and the procedure of what's to occur. I'll go through a bit more of that in performance management, but you can imagine the kind of issues that do pop up where a procedure isn't followed for those kind of complaints. Expenses. So if you've got a client whose business that they allow employees to incur expenses, it's very important that that policy is written down as to how they're to claim the expenses and also what expenses they're allowed to claim. The last thing an employer wants is for a staff member to go out there incurring all these expenses without any authorization, and then the employer's up for those expenses from the employee. Another very important one is an alcohol and drugs policy. So an alcohol and drugs policy is exactly as it sounds. It sets out whether people can work whilst intoxicated, what level they can be intoxicated, what the expectations of the firm are or the business are in relation to the alcohol and drugs policy. Often here, when dealing with, say, mining clients or construction clients, there are companies now who run, their whole business is around alcohol and drugs policy. So what they do is they actually come into a business, they write up the alcohol and drugs policy, and they do testing on a regular basis. They get everyone to consent to it, and then they come in and do the testing to make sure that the alcohol and drugs policy is being met. Once again, that's a very important thing to do. I've had clients come to us who just want to institute random alcohol testing. In fact, I was just chatting to one the other day. They just wanted to institute a random drug policy and alcohol policy. And they can't just do that. They need the staff to agree. Now, obviously, as an employer, you're going to find out pretty quickly whether people are breaching that on a regular basis if you're doing regular testing, and they'll probably leave before that occurs. But it's a very important one to get right. The next one is a dress code. So in any sort of business, you may have an expectation of how people are to dress, whether it's an office, so they dress professionally in suits or casual Fridays, and what's to be met in that dress code. So setting out that kind of policy is very important for those people to be able to understand. Pay reviews and performance reviews, those kind of things need to be set out in a policy as well. Managing other grievances and conflicts. So as anyone attending this webinar will know, if you've got conflicts in the workplace, it's very important that there's a level of understanding for employees of how they're to deal with conflicts within the workplace. You don't want people tattletaling on and gossiping amongst themselves. So having a conflict grievance procedure for other types of conflict is very important. Information technology and how it's to be used. Once again, this is another area that's becoming more and more important as the internet evolves. Facebook and Twitter and other Google Plus and all those other, and LinkedIn even, they're things that people are exposed to, and the people can be seen as part of the business. We've had clients before who have had their staff members being friends with clients of the employer. The employee posts a picture of themselves doing, say, a beer bong on a weekend, and this has actually occurred, and the client has rung up on the Monday saying, I don't want to deal with this person, I don't want to deal with your firm anymore because I don't want to deal with that kind of person. Now, that can have serious ramifications for a business, and if an employer doesn't have a policy in place on how staff are to deal with information technology, and those kind of social media, then there's nothing that an employer can do about it. An employer needs to set those policies and procedures in place and make sure their employees understand that they are, no matter where they are these days, they are on show for the business, and it's very important that happens. The last policy is about performance management, which I referred to before, and I'll talk about that now. So performance management, what is it? Performance management is something that very few employers like to actually get involved in. The amount of times that we see clients who don't want to deal with it is not unsurprising, but it's very important part of the business to get right. And where this is important for you guys as accountants is to be aware of where clients may be having performance management issues and they're not addressing them. So I'll go through some of the strategies that are applicable for performance management, and I'll talk about some examples of where that falls down. So the different strategies really there's really three of them. The first one is counselling. So this is where you've got a minor problem with an employee and you want to sit down and have a chat to the employee and try and counsel them through it. The problem with the counselling process is that sometimes where you counsel an employee a number of times, that you may not wish to go on to the next level of warnings, and the employee might start to think that their conduct is okay. So you need to use counselling on very minor problems. Where warnings come in is for more serious problems or for repeat problems. And it probably comes as no surprise to everyone on this webinar that this is one of the biggest things that people get wrong. And it's important to get it right, because if you don't, as an employer, you can get up for unfair dismissal claims. And the advice that I'm giving today about this is all about trying to prevent your clients from having performance management issues and having unfair dismissal claims. So the warning system is no longer set in stone. It used to be that you had to give 3 written warnings and then you could fire someone. It's no longer the case. There's also no set period of the time that you need to give the warnings, the period between them. So you could give someone a warning on one day, and if the conduct increases, then it can be given the next day, or it can be given the day after. And the perfect example of that is someone turning up to work late. So if the person's hours of work are 8:30 and they turn up on a Monday at 9:30, they then, without an excuse, of course, they then turn up at 10:30 the next day and without a valid excuse, and then 11:30 the next day without a valid excuse, then there's nothing wrong with giving 3 warnings in 3 consecutive days. If it's, say, a performance issue relating to their performance and their billings or their performance of their work, then that would need to be on a more long-term basis. Say if it was a billings goal wasn't being met, then you'd have to performance manage that employee through a number of months to make sure that they understood the problems and they were given an opportunity to rectify the issue. As I said earlier, or as I alluded to earlier, one of the biggest issues with warnings is people not giving them early enough, and people and employees thinking that their conduct is okay. So where you hear clients starting to talk about problems they're having with their employees, they really need to get onto that sooner rather than later, so that they're not caught by the fact that they haven't given the right warnings at the right time. And in not doing it, the classic example, a large client of mine came to me about 6 months ago, and they had an issue with an employee who had consistent problems that were leading to them being fired. The problem was that they were never being told that these were problems. They were arriving late to work. They weren't doing things properly. And because they weren't given proper warnings, they then had to go through a performance management procedure. They didn't do that, and they had an unfair dismissal claim come against them. And so we had to act for them to defend that unfair dismissal claim. So doing it right is very important. Further training or support. So the third way of dealing with, or a strategy for dealing with performance management is to set them up with a more senior person in the business. Obviously, this doesn't apply to a small business, it applies to a medium-sized or a large business, but set someone up with a bit more experience who can give that person some guidance as to what they're to do and how they're supposed to be doing things. And then that person would report to the business owner about the types of issues and make sure that they're actually, the person who's being managed is reaching those goals. So they're the three ways to performance manage an employee. And as I say, the biggest issue comes from, I'm probably repeating myself a bit here, but it comes from people employers not getting onto problems early enough and not giving proper warnings. So if that occurs, then you need to get and you hear that from your clients, they need to get onto it quick, smart, to avoid problems later on when there is something, if the problems brim over the cup and they just can't deal with the problems anymore. The next thing that I'm going to talk about is the performance meeting. So this is just a quick overview about how a performance meeting should be conducted. Now, it may sound elementary, but it is surprising how many people don't do this right and then come to us with an unfair dismissal claim because they don't think that, or the staff member doesn't think that they've been dealt with properly. The first most crucial thing is that you've got to ensure that you're prepared. Make sure that you're taking notes, that you go into the meeting with an agenda, and that you've organised the whole meeting properly. Booking a quiet and private meeting space and doing it discreetly is so critically important. You don't want an employee thinking that they're being shamed in front of the rest of their staff because there's a meeting going on about their performance with the door open, with everyone able to hear. Voices might get raised, and everything's embarrassed. Everyone's embarrassed by the whole thing. Book a meeting with the person and advise that they can have a support person. So once again, this is critical for a meeting with an employee. There's a great power imbalance between employers and employees in most businesses, and the employee might not feel that they're comfortable in saying something. So allowing them to have a support person there is also really, really important. It also lets them feel that they've got a witness to what's said and gives you a witness to what's said as well, so that there can't be any arguments over that. So any employer should also have someone else from the business, whether it be a business partner or a senior manager, in that meeting, so that there's two people on each side, so that people can verify what's actually being said. At the outset of the meeting, explain the purpose of the meeting and what the participants and their roles. So normally there'll only be one or two speakers. Oh, sorry, two or three speakers, I should say. The support person on either side usually doesn't speak, and the grievances are raised through that process. The performance issues need to be worked through, and the employee needs to be given a chance to respond to each of the issues, and then the employer needs to make notes on their responses. The employer then needs to explain the level of performance that's required and confirm the timeframes that the employee is going to reach that level. And then the employee always has to be given an opportunity to add any other comments. Then a summary of the outcomes and the next steps need to be gone through. So there needs to be a plan of how you're going to get the person through to meet the performance standards that you require. And then very, very important is that you have minutes that are countersigned by the employee. That's very important to document what's actually been agreed, because if you don't, then the employee may go out of the meeting with one idea, or they might say they come out with one idea and the employer goes out with another idea. So that's the basics of a performance meeting. As I say, no one likes doing them, but sometimes they're critical in any business. Now, I alluded to before the Dropbox link that has the resources in it. In that is a frequently asked questions. Now, this has been prepared by a company called Employee Matters. It's a company that, as Craig mentioned before, we do a lot of work with. And Natasha Hawker, who's the lady who prepared these frequently asked questions, has actually written a book on this. And I was actually reading through her book in preparation for today, and I saw these frequently asked questions, and I immediately sent her an email because I thought they really encapsulate the questions that people and employers have about performance management. And she very kindly put these onto a A4 sheet of paper in a PDF for us. It's 3 pages, and I think that this is a really great resource for a cheat sheet for employers and even us as consultants to have handy to be able to answer any quick questions. So don't have a read of it now unless you really want to. Have a read of it later, but it's a really valuable resource that Natasha's very kindly allowed us to hand over today. As I say, it's out of her book, and it's tried and tested material and stuff that it's really important for people to know. As I say, people as in employers. So the next and last topic that I'm going to talk about is exiting employees. Now, what we're really talking about here is serious misconduct as opposed to performance. I've talked about performance, and I will talk about it a little bit at the end, but this is where things get really bad in a business. Now, there are many different reasons to move on employees, but generally the main ones are inappropriate behaviour and fraud and theft. They're the serious misconduct ones. So inappropriate behaviour, the classic example is an intoxicated staff member at a work function doing something untoward to another staff member, or doing something untoward in front of a large group of people. Yeah, you've probably all heard the stories. The classic example is someone takes their clothes off in front of all the staff, or inappropriately touches another staff member, and the other person feels uncomfortable with that, or other people feel uncomfortable with that. And so it becomes a problem with the business. Companies like Employee Matters and us lawyers, December, January is a great time for this because all the Christmas parties happen and everyone goes out there getting drunk, and at times people do inappropriate things and they have to be dealt with. So the very simple way of dealing with inappropriate behaviour is that obviously needs to be a complaint. There needs to be a formal meeting put to the staff member who's alleged to have done the wrong conduct. That needs to be put into writing so that it's very clear about what's been discussed. There needs to be a formal investigation conducted. Normally, at this point in time, that staff member would be stood down, depending on the seriousness of the allegation and their importance, I suppose. But normally they would be stood down. It'd have to be a very good reason, and that'd have to be very important for them not to be stood down. The formal investigation would have to be conducted into the witnesses, the person who's made the complaint. All of that would have to be done with employees and other witnesses. So normally these things happen at an event, so there might be staff at that event, at that function centre, say, or nightclub or something that would be aware of those things. Then the findings need to be shared with the respondent, and they're given an opportunity to respond. Again, they should have a support person with them, and they should be given the opportunity to take legal advice. Based on their response, then the employer makes a decision about whether or not that staff member should be fired or should be managed, and that's obviously done in concert with any person who's made the complaint so that they feel comfortable. So there's really three outcomes that can come out of these meetings. One, to find that the behaviour did not occur, that it was just didn't happen, that there were extenuating circumstances, or it was minor in nature, or that the behaviour did occur. And where it did occur, normally the person would be moved on. Another example I had from a client is where someone at a staff function, they're all staying at a hotel, and one of the staff members defecated in the hallway. And obviously, that was witnessed by a large number of people, so that person was moved on pretty damn quickly, as you can imagine. So the second serious misconduct is fraud or theft. Now, fraud or theft are criminal charges. So for an employer to allege that an employee has done either of these is very important. And it's something that's very rarely discussed between business owners, because they find it embarrassing that they've, one, hired a staff member who will do this, or two, that they've they didn't know what was happening. So, and let's face it, most people are honest, and they believe that other people are honest too. So before any allegation of fraud or theft can be taken any further, you need to, as I say, have prima facie evidence that the conduct did occur. The classic example with fraud is signing a letter or signing a check on behalf of someone. Or taking money out of an account. It will, if that kind of thing occurs, then you usually can be pretty certain as to how that's happened. The other one would be that for theft would be stealing a motor vehicle, as I said before, if that was actually stealing. In the case of the example I gave earlier, I don't think it actually is, but but where it's actually stealing a company vehicle or company property, then that could be an issue. Again, you need to conduct a meeting to put the allegation to the person. The employee should be suspended until you have enough. As long as you've got enough evidence. This usually needs to be on full pay, and I think in this situation, the client should always consult with lawyers or employment consultants to make sure that the fraud or theft is actually serious enough and they have enough evidence, because getting it wrong can cause serious issues. So a formal investigations is undertaken. Then the outcome of the meeting is taken, and the investigation is taken to the employee and put to them with their responses. If it is shown that the fraud or theft has occurred, then the employee should be exited immediately, and then you should also consider contacting the police. Obviously, that's a serious allegation. We've known situations before where employees haven't haven't reported to the police because they didn't want to ruin that person's life. But it's very, very important to get that right. Now, the overall cost of unfair dismissal, is very, very, very expensive. So, if you have to go to court and defend yourself, if you're not sure, then paying out someone a little bit of money to make them go away so they don't have an unfair dismissal case against you may be the best way of going. As I said, the last issue is performance. So, as I said earlier on the last slide, if you've got performance issues with employees, then they need to be dealt with in a fair and reasonable manner. And if they're not, then an employee can bring an unfair dismissal claim. But with the right advice, employers can usually get that right. And getting the right advice early and doing it before you go terminating people is very important to get right. Okay, so that's it from me and from Craig on our topics. If we've got any questions from anyone, we'll give a few minutes for people to ask questions if they've got any. Whilst we're waiting for that, I'll just point out the fact that what we're going to do, as we do with all these seminars, is this is being recorded. That will be put into the Dropbox folder, and that link will be sent around to anyone. So if you've got any questions afterwards, or that come up afterwards, please feel free to email Craig or I. There are our email addresses on the slides. Okay, so a question's been asked: with the standards and policies, do employees need to sign acknowledgement that they have read the policies? Look, the short answer is yes, if you can, especially if you're introducing those policies later on. So if you're introducing the policy to an employee who's been with you, a month, 2 months, 6 months, a year, 10 years, they should sign that policy. When someone starts in a business, usually the first thing we do is get the employee to sit down and read through all the manual and then get them to sign an acknowledgement to say that they've understood the policies. So I think it's a good idea because, as I said earlier, the ignorance of the law is no excuse, but ignorance of these policies can be the excuse if you can't show that the person can actually, should have actually seen these policies. What happens if the employee refuses? Great question. If they refuse, then I would say that would be grounds for dismissal because you have to question why they want to refuse. I suppose it depends on the type of policy and whether it's fair or reasonable. So I think that if they refuse, then you can move them on, and if they refuse too, serious counselling needs to happen about why they actually won't sign the employee policy, because it's usually there's a concern. A question's been asked here: if a CEO dismisses unfairly, are they personally liable or the company? Usually the person doing the dismissal isn't liable. You'd have to show some very serious personal reason for the person doing the dismissal to be held personally liable. It's usually the company that's held personally liable. But I guess if you could show that there was some sort of malice or something, Craig, you probably see that would be the case.
Yeah, potentially. But most of the time, it would definitely be the company, not the CEO or the individual person.
Absolutely. All right. The other question that's been asked is: do you need separate policies for exiting managers and employees? The short answer to that is maybe the great lawyer answer. Potentially, if the if you've got a big enough company with a big enough structure. So if you're dealing with a company like Apple, then you might need to have a separate policy because you'll have different people in different positions. For most small to medium-sized businesses, no, you'd have the one policy with all the different employees and managers in the one policy. I think I'll hand this question over to Craig.
So the question is, with the subcontractors retrospectively having tax paid, is the tax on top of the payments?
So I think this is asking Craig what we've been asked this question, a similar question before, where do you have to pay tax on top of the payments?
Right. No, well, it should be, if you're paying what you think is an independent contractor $1,000 a week, for instance, and that was to be inclusive of tax, then the tax office would actually say that independent contractor is supposed to have paid the tax and pursue them for unpaid tax.
But you still get the fines.
You'll still get the penalties and the fines, interest, etc., but not the actual tax. I think that would answer your question.
Let us know if it doesn't, Tracy. All right, well, I think we'll finish up there. If you've got any questions or you want to get any further in depth with us about these questions, we're happy to answer them. As I said, follow us on Facebook, Twitter, and Google Plus and LinkedIn. We're on all those platforms and we post regularly, so feel free to do that. And feel free to, as I say, ask Craig or any questions on any of these issues or any other issues that you may have. Thanks very much.
Thank you, everyone.